I'm going to call David Clendon.
Thank you, Mr Chair. Mr Chair, reading the reports of the Justice Ministry, one could be forgiven for thinking all is well, that certainly the Ministry has not been idle, nor has the Minister over the previous financial year. There has been legislative change, there have been new programs implemented, a lot of change, a lot of restructuring. What's not so apparent, one has to dig a little deeper to discover that actually we have a very serious problem in New Zealand emerging in terms of people's access to the justice sector and particularly to the courts. And largely, or one of the major barriers to access to justice is a financial barrier, and that's becoming a very serious problem. So the former Chief High Court Judge Justice Helen Winkleman commented on this last year in the Ethel Benjamin address, where she talked about the justice gap that is emerging and indeed widening in New Zealand. And she pointed to one of the primary symptoms of that, which is dramatic increase in the number of people self-representing to the courts, so-called self-litigants, people endeavouring to navigate their way through the court system unaided by by professional legal assistance. The Ministry's only recently started to record the numbers of people self-litigating, but it's evident anecdotally and from informed members of the judiciary, of the legal profession, that the numbers are increasing dramatically. In the Wellington High Court last year, some 20% of active appeals involved self-represented litigants. In the Auckland High Court, the figure was around 30%. Something like 50% of applications to leave to appeal in civil cases in the Supreme Court last year, over 50% of those Supreme Court applications were people intending to endeavour to represent themselves. And that is a symptom of something seriously wrong in our justice system. We live in a liberal, democratic country. The people of this country expect to have access to the courts to resolve their differences, to defend their rights or to assert their rights, whatever it might be. We're fast reaching a position where New Zealanders will be able to rely on one thing, and that is that they can get the best justice that they can afford. And that's not a situation we want. So the cost of a simple, straightforward one-day hearing in the High Court, approaching $7,000, simply for filing fees, scheduling, the cost of the hearing, the sealing of the judgment, almost $7,000 before anybody gets anywhere near a lawyer. And so that's beyond the ability of most people to pay. Certainly the registrars can choose to waive, and on occasion they do, but nevertheless the barriers are mounting, the financial barriers are becoming serious. We have a legal aid funding system, of course we do, and as a previous member has commented, the financial threshold for eligibility is set extraordinarily low, ridiculously low in fact. For a single person, a gross annual income of $22,000 or less before one can apply for legal aid. That is significantly below the minimum wage for a person working full-time. For an applicant for a partner or one child, $35,000. Again, that is a very low income by our current standards. Justice Winkleman has commented on that. And pointed out that that is simply inadequate to allow legal practitioners to do any useful work for their clients. In the event a person is successful in getting legal aid, they may be obliged to repay that money. If they are so obliged, they have 6 months to pay it back, or 8% interest is applied to that money, getting people further into a financial hole if they haven't had the money to come up with that. The Dean of Law at Canterbury University, Dr. Chris Gallivan, wrote recently that the deficit between eligibility for legal aid and the reality of paying for legal representation is large and places a significant number of middle class in an intolerable situation. It's been noted that large number of lawyers and legal firms are simply withdrawing from legal aid because with the best will in the world, they simply cannot afford to devote hours to that work, given the cost, the legal obligations placed on them and the associated cost of running a legal practice. They simply cannot afford to participate in legal aid work to the extent that they might wish to, and that indeed that we require. Some of the slack, as we know, has been taken up. Thank you.
Kelvin Davis.